Okay, so I will kick off. So it's our great pleasure, mine and Marjolaine, who is the organizer, of this webinar, to welcome you for the third edition of our Zoom-in webinar. We had more than 130 registrations, so this is growing much faster than what we thought originally. Thank you for that. Today, as you know, we'll be talking about a much discussed and expected award of the Court of Arbitration for Sports in the WADA RUSADA case. The case is a relatively distant aftershock, I would call it, of the so-called Russian doping scandal, triggered by, you will remember, the investigation of a German journalist back in 2015, and the subsequent rocambolesque escape and in a way, confession of the former director of the Moscow laboratory, Grigory Rodchenkov. The decision was rendered on 17 December of last year. It was very much commented in the public sphere and received quite a few critical reviews for its apparent, I would say, leniency. For example, in the New York Times, it was reported that Travis Tygart, the chief executive of the United States Anti-Doping Agency, labeled it a weak, watered-down outcome and a catastrophic blow to clean athletes, the integrity of sports, and the rule of law. The Guardian's report on the case was headlined, "Decision to halve Russia's WADA doping ban met with disbelief and anger." And INADO, the Institute for National Anti-Doping Organizations, press release was entitled, "CAS Decision on Russia Sends a Confusing Message." Well, you get it. It was not the most popular decision of the CAS by far, maybe a close second after the Semenya Award. Unfortunately, and this is a separate matter that is important to me, the award was not made immediately available at the time of the press release, but only a month later. So I think this is in itself a big issue. It damages the quality of the public discussions because all these commentaries were done on the basis of a very rudimentary press release and not on the basis of the CAS's holdings. Now, finally, we have access to the quite lengthy, so it's around 180 pages, text of the award, and with Marjolaine, we were very eager to organize a Zoom-in around these decisions. And we're very happy to be joined today by three very prominent speakers and experts on these discussions. Herman Ram, who is the president, not the CEO, the president of the Anti-Doping Authority of the Netherlands since now 2006, and is also a member of the board of the Institute of National Anti-Doping Organizations. Michel Verroken, who is a well-known anti-doping advisor for a number of sports governing bodies and a lecturer at De Montfort universities and the former director for ethics and anti-doping at UK Sport. And Jean-Louis Chaplet, who is an emeritus professor at the University of Lausanne and one, or if not the world's finest connoisseur on the governance of global sports. And in recent years, if you want to check it out, he has published a number of articles also on the global governance of anti-doping, and in particular after the Russian doping scandal. So before we give them the floor, Marjolaine and I will provide a very short, or a relatively short, but hopefully quite complete introduction to the award and its main points. Marjolaine will start by briefly contextualizing the award in the wider series of legal developments that were triggered after the start of the Russian doping scandal. Marjolaine, go ahead.
Yes, thank you, Antoine. So as Antoine said, the CAS Award did not come out of the blue, far from it. And it all started, as Antoine mentioned, with a German documentary, and I'm trying to give you a little bit of context or a reminder of the context and the chronology of the events. I'm just trying to look for a very sophisticated slide I have here. Just bear with me for a second. So here it is. So there are basically, I'd say, two strands of proceedings. There is one strand that we can refer to as a sort of regular anti-doping proceedings against individual athletes that resulted from the, particularly from the second part of the McLaren report, were based on these investigations on the laboratory data and other elements. And the idea is that these would result in individual disciplinary proceedings conducted by international federations or by the IOC under the WADA code and establishing anti-doping rule violations against individual athletes. Now, the second strand, which here I call institutional, relates to the shortcomings of RUSADA and the Russian authorities. And these resulted for a first time in 2015-2016 in a first non-compliance notice. So as you know, RUSADA was suspended a first time for quite some time. So that was the first act. And then in September or late 2018, after a roadmap to reinstatement, WADA decided to reinstate RUSADA into its position, but subject to an important post-reinstatement condition, which was providing an authentic copy of what has become known as the LIMS data, so the Laboratory Information Management System data of the Moscow laboratory. But then after finally obtaining the data, because it took some time, the WADA Compliance Review Committee reached the view that the LIMS data provided had actually been manipulated. And this resulted in a second non-compliance notice. And this is where it's important to understand the technicalities of the new international standard for code compliance by signatories, so ISCCS, that came into effect in early 2018. And under this standard, WADA has no authority to issue a decision against the signatory. What WADA does is it issues a notice to the signatory. The signatory can then choose to accept the notice and or the consequences, or to challenge it. If, as RUSADA did in this case, the notice is challenged by the signatory, then WADA has to move the case forward and bring it as ordinary arbitration proceedings before the Court of Arbitration for Sport. And this is why actually in the name of the case we have WADA versus RUSADA, not RUSADA versus WADA. So that is how the proceedings started.
Mm. So back to me. We're doing a bit of ping pong, but so now you have I think a clearer understanding of where the word fits in the saga. Let's call it the saga of the Russian doping scandal. And now we will just go quickly into what's in the word. What's the substance of the holdings of the CAS. Maybe one quick point, preliminary point. I think there are two discussions that we will not touch upon, but that are quite relevant as well, or quite important, that relate both to the nomination of the arbitrators and to the selection of experts. So those were preliminary matters that were quite controversial between the parties. We will not touch upon them, but if you want to look into that, there are two discussions in their words that are I think worth a read. We will focus rather on the substance in terms of the application of the ISCCS, and we will repeat this acronym quite a lot during our 1 hour and a half. I will focus on the first, what I would call the first part of the word, which is mainly about the applicability and the applications and the application of the ISCCS. and then Marjolaine will provide a brief introduction to the part called signatory consequences and not sanctions, and she will explain that a little bit in greater details. So let's talk about the validity of the ISCCS. So first, a little note of context. So what is the ISCCS? Well, it's mainly WADA's response to the Russian doping scandal and to basically the core lesson of the Russian doping scandal was that there is a big gap between the idea of a global anti-doping regulation, global norms, and local practice. And the scandal basically highlighted what I called back then the global structure of the world anti-doping regulation. It might look like a global system because there is one code, there is one set of standards and so on, but its practical implementation is actually deeply local. It depends a lot on where you are on the planet, basically, in terms of implementation. And the ISCCS is a bit of a response to that kind of empirical situation. And it aims at basically raising WADA's capacity to police those local realities, to make sure that they are somehow commensurate to some extent. They will never be commensurate. A lab in Lausanne is not the same as a lab somewhere in the middle of Africa that doesn't have the same type of resources. That will never be true. We have to be aware of that. There will always be a local dimension to anti-doping. But at least there would be more policing of what happens at the local level. And this is, let's say, the essence or the function of the ISCCS. But we need to keep in mind that WADA is still a very small organization. I mean, it has barely, I think, a little more than 100 employees. It has not more than 10 people working on compliance and on investigations. It has very limited means to actually police what's happening around the world. So it has to make choices, difficult choices, and pick its battles. And that's what happened in the RUSADA context. WADA decided to pick a battle and to focus on RUSADA's compliance with the ISCCS. So that's a bit the background of the ISCCS. And the first objection that was raised, and that is crucial, that was raised by RUSADA, is that it was not contractually bound by the ISCCS, that it had never consented to it. And it had never consented to the WADA Code 2018. It never objected to it, but never consented to it. And you have here again to remember that the WADA Code is framed often as a global governance tool and so on, but it's formally, legally a contractual construct. So the idea is that you can be bound by the WADA Code only because you are contractually signing up for it. It's only the signatories. So if there is no consent to it, then you are not bound. And this is, in general, the way in which anti-doping and transnational sports law works as well. I mean, I've discussed it in the context of CAS arbitration. There is always the fiction of consent, at least, which is usually and very often forced because you don't have a choice. Either you join in or you're out of global sport. But the fiction is consent. So the CAS has had to deal with the question, well, is RUSADA bound by this ISCCS contractually? And here I think are two of the most important holdings of the award at paragraph 554 and paragraph 555. 554. There is much force in the WADA submission that acceptance of the RUSADA argument would mean that the signatory would have never objected to the ISCCS, never commented on it, nor voiced concerns, and not sought to terminate its signatory status, could simply, when faced with a compliance action, say that it was not bound. If that were right, there would be no certainty as to what rules the signatories were bound by. And moreover, different signatories would perhaps be bound by different rules depending on their factual circumstance. And then it follows up in paragraph 555. And it says that indeed, the WADC in all of its version foresees that WADA would enter into identical and parallel contractual arrangement with each signatory. This is significant because it indicates that the basis of each individual agreement was that other signatories were bound by the same provisions in exactly the same manner. If different signatories were to be bound by different versions of the WADC or international standards, there would not be a level playing field for athletes. So the foundational ground to support the validity of the ISCCS, we are coming back to that key element, is the need for a level playing field. The CAS recognized that in a way, RUSADA never consented to it. But as it entered into that anti-doping system that has as a fundamental objective a level playing field, it had to accept that it be bound by the entire system like all other signatories. And that means as well by the ISCCS. And that's how the CAS constructed or accepted to recognize that RUSADA was bound by the 2018 World Anti-Doping Code and by the ISCCS. And that there is no a la carte consent in a way. You are in or you are out, but you cannot pick and choose. And that would be contrary to the whole idea of a level playing field. The RUSADA had also raised a number of objections under Swiss law, which I will not touch upon, on the validity of its consent or the contractual bindingness of the ISCCS. Regarding the application of the ISCCS, and that's my final remark for today, the CAS discussed at length RUSADA's obligation to comply with the post-reinstatement data requirement, basically to deliver the proper Moscow lab data, non-doctored Moscow lab data. And the question was whether, RUSADA could be held non-compliant when it was not responsible for doctoring that data, when a third party had messed with it, and it could not control that messing because it was, let's say, the Russian state or the Russian secret services. So are we in a position to accept no fault and strict liability in that context? And here again, three very important holdings, and then I will close my intervention. One is paragraph 595. And there the CAS panel says, there can be no serious challenge to the proposition put by WADA that if a national anti-doping organization could avoid a compliance action by blaming the interference of public authorities or other third parties, the system would be toothless. It would mean that countries with unscrupulous governments or sports authorities with the power and the will to undermine proper anti-doping regulation would be able to do so without consequences. So that, in effect, the overriding aim of harmonized anti-doping regulation would only be possible in those countries where authorities were willing to play by the rules. If you don't accept strict liability, well, there will always be a state, and misintentioned states ready to intervene, and then nobody will be sanctionable. And that is a fundamental point, to extend a non-fault-based responsibility to RUSADA. And that point is elaborated on then in paragraph 608 and 609. I will not read them out, but you can check them out. And it seems also reasonable when you expect, obviously, from athletes to submit themselves to a system that imposes strict liability, that this system be as well applicable to the signatories. In effect, it's a very interesting dimension of the word, because what is the CAS saying? It's saying that even though RUSADA is a signatory, we know that in practice, RUSADA is signing also for Russia. It's in a way acknowledging that RUSADA has to be responsible of the behavior of the Russian state. And that's a rare acknowledgement in the world of global sports of the not entirely apolitical nature of sport, of the fact that sport is not totally autonomous from state authorities. and that state authorities are really, in many states, involved in many ways in the regulation and the functioning of sports. So these are the 2 points that I wanted to highlight. And now I turn the mic to Marjolaine to discuss about the sanctions / consequences.
Yes, so as for an ordinary anti-doping rule violation, the CAS award was organized in these 2 sections. So first is there non-compliance, and then what are the appropriate consequences for the non-compliance. And there, well, I won't go into the details, but let's say for the panel did follow WADA's prayers, but only to a certain extent. So for the most obvious aspect of it, the panel reduced the duration of the consequences from 4 to 2 years, mostly for considerations of proportionality, and Herman Rom will add some comments on proportionality later. The fine against RUSADA was upheld. Then the scope and reach of the exclusion of Russian officials was somewhat reduced, and in particular for representatives of the Russian government, so they can still be elected in a personal capacity to bodies of the IOC or the IPC. Then third, and another interesting aspect is that the panel had a rather generous analysis of what it meant not to show the Russian flag. So the flag still remains allowed if it is in the spectators areas, and if it is necessary to identify technical officials of Russia during events. But then, and then finally, well, one of the most awaited aspects of the reasoning was what would be the outcome for individual athletes and the support personnel. And then, so there are 2 points I'd like to highlight. The first was this question of whether adverse consequences to Russian athletes are to be characterized as a sanction or not. WADA's position that was followed by the panel was, and I quote, that a sanction must be designed to punish misconduct by the addressee of the sanction. And here, therefore, for WADA, in this case, athlete non-participation was a form of reflex effect of contracts by WADA with signatories of the WADA code. So non-participation was not a sanction because, in particular, and again I quote, there is no will to punish. And so this reasoning was then followed by the CAS panel after also relying or discussing some legal opinions. And the conclusion of the panel was that the parties had not identified any authority or jurisprudence that would speak against the solution of applying this, let's say, the finality of the criterion of the finality of the adverse consequence to identify a sanction or not. So there was little consideration given by the panel to this argument that you should also have regard to the impact, for example, of the measure, rather than only the intent or the declared intent behind the measure. And then second, what I was also missing a little bit in the award is the discussion of how WADA could construct an authority to issue directly, whether it's called sanctions, consequences, or ineligibility rules, but to issue directly consequences against individual athletes. But in the end, the panel found that it had the distinction between consequences and sanction had little consequences, because in any event, any adverse effects of the consequences on third parties would be considered in light of proportionality. And this is where the second and last point that I'd like to highlight comes in, is the question of the conditions for participation of Russian athletes as neutral athletes. And there, the panel refused to make the participation of the neutral athletes subject to them showing that they were not implicated in the doping scheme. So what WADA contemplated was that they would have to show, in particular, that there was no incriminating data from the McLaren report against them, that there was no manipulation of their data recording, and then the important third requirement was that they would have been subjected to sufficient testing prior to the relevant event. So the panel said, and that's in paragraph 770, and I quote, "This would be excessively burdensome and inappropriate in the circumstances to require Russian athletes and athlete support personnel to bear the onus of proving they were not affected in any way, etc., by the manipulation of the Moscow data." So the panel found that this would be excessive and also impracticable in terms of legal certainty, because they also raised the argument that this would avoid ancillary disputes and provide, it was important that the award could provide finality to the dispute. And finally, also an argument of, let's say, of the opportunity or broader context, saying that to impose more severe consequences upon new generations of Russian athletes would go further than necessary to achieve the objectives aimed for by WADA. So these are the 2 points with respect to the individual consequences that I think are important. Now the result is that athletes, Russian athletes, will now be allowed to compete as neutrals unless, but this is already evident, unless they are subject to a period of ineligibility or are barred from another reason from participating in the event. So they will carry no burden of proof to establish any further conditions. Well, then after this let's say short, little bit pointillist introduction, I will hand over the mic to Herman Ram for some further insights into the proportionality of the consequences.
Thank you. And thank you everybody for having me and for listening to me. I have about 10 slides for you, which I'm going to show right now. I hope you can all see them. Right, okay. I basically will try to answer 2 questions in the upcoming maximum 10 minutes, probably a bit less. One of them is, how can the leniency be explained? And already Marjolaine explained what aspects there are in the leniency. And the second question is, how does this approach, this leniency, relate to tampering cases where athletes or other persons are involved? So how do you compare a tampering case of a coach signatory to a tampering case of an athlete? Those are my 2 basic questions, and I'll try to explain them. But the problem is that very little is said about that in the actual award. WADA has written a legal note, and I quote from it right here. The bold is always by myself. In the original, of course, there's no bold lettering. And WADA explains that basically explanations are very scarce in the award. They say it's not comprehensively explained. Well, probably whoever wrote it was in a good mood, because I'd say it isn't explained almost at all. So apparently, was WADA's conclusion, apparently the panel considered somehow that it could do with less consequences than asked by WADA to achieve the same goal. And we'll look into that shortly. So the problem is, if you read the award or twice or 3 times, you won't find much of an explanation for the lenient approach. And it is lenient, and already Marjolaine explained that, so I can be very quick on this slide. quite a number of aspects. Some of them weren't named by Marjolaine, but the most important one, of course, were already mentioned. It was really watered down compared to the consequences that WADA was looking for. And not on one aspect or two aspects, basically on almost all aspects. So that is quite a thing to do. I mean, this is one of the most important CAS awards in anti-doping, if not the most important CAS award on anti-doping ever. And then it's quite astonishing, basically, that there is so little explanation. So I'll try to look into what there is as an explanation, and you can find in the CAS award under number 861 two reasons. And the first one is the panel was limited by the powers granted under applicable law, and they refer to the World Anti-Doping Code and the International Standard for Code Compliance of signatories. So what I did is, let's look into that. What does it say? And of course, the specific rules about sanctions are not in the World Anti-Doping Code, but they are most specifically in the International Standard. So I decided to look at the International Standard for Code Compliance. Well, it says in paragraph of Article 10, well, quite some things about the consequences. And I quote the most important parts of that. And the first one is that the consequences shall reflect the nature and seriousness of the non-compliance. Well, there's, I think, very little doubt that this is the most serious case we ever have been confronted with. So it's the seriousness of this case, in my opinion at least, doesn't leave much room for leniency. The second one in 10.2.2 is about aggravating factors. And in this case, there were quite a number of aggravating factors. And the international standard says, well, if there are aggravating factors, you should find that back, you should recognize it in the consequences. Then 10.2.4, well, they say you shouldn't go too far, basically, in sanctioning. You should sanction as far as necessary, but still, it has to be enough to deter further non-compliance, not only by this signatory, but by other signatories, to incentivize all signatories, and to assure that there is code compliance. So even if you take this part of Article 10 as a possible way to be lenient, it still is most certainly limited in how far you can go. And then I come to the most important part, and not because I say so, but because the international standard says so itself. Above all else, and I'm going to read it literally, the signatory consequences imposed should be sufficient to maintain the confidence of athletes, other stakeholders, and the public at large in the commitment of WADA and its partners, from the public authorities and from the sport movement, to do whatever is necessary to defend the integrity of sport. This is the most important and fundamental objective overriding all others. And how on earth, having read this, can you come to leniency? So my first conclusion is predictable, but I think quite simple. The applicable law, which is the International Standard for Code Compliance of signatories, is not reflected in the award. The facts and the circumstances of the case are extremely serious. And there is, in my very strong opinion, a contradiction between that, the consequences, and the criteria of Article 10, which I just showed to you. Then I move to my second question, which I try to answer, because there's another explanation in the award, still in 861, for the leniency, and it said it has considered matters of proportionality. Well, okay, let's look into that. And the proportionality is specifically meant to affect cultural change and encourage the next generation. That's new. I never heard of it before this one. But of course, it's a possible approach. It may be a very good approach. whatever you think about the consequences itself, taking this kind of stuff, cultural change and encouragement into consideration could be very sensible. But if at the same time it would have been an athlete, would that also be a possible approach? Would a panel be allowed to take that in consideration if it was a case about an athlete or another person, like a coach or whatever? The answer is no, because in Article 10.3.1 of the Code, it shows that there are only 3 ways to diminish the consequences for an athlete or another person. 1, if it is a non-intentional case. Well, this case, of course, was very intentional. If there are exceptional circumstances, or it is a protected person or a recreational athlete. Those are the only 3 escapes that the World Anti-Doping Code allows if a tampering case is about an athlete or another person. So it's a completely different approach. The International Standard for Code Compliance leaves room which is simply not available if it concerns an athlete or other person. So then I decided to go into the jurisprudence to look how actually in reality CAS is dealing with tampering cases if there are athletes or other persons involved, to compare them with the RUSADA case. Well, I found in our database, www.doping.nl, whoever doesn't know it, please go there because it's an extensive collection of decisions. And it contains 82 CAS decisions about tampering and attempted tampering. And I don't think there are much more decisions than those 82. Well, the first way to diminish the consequences is protected persons, which basically are minors or have been minors in the last years. None of the cases was about a minor athlete, so that didn't work out. Then about intent. Well, indeed, there were a few cases where the tampering itself was proven, but the intent was not proven. And in those cases, there was a reduction of the consequences. In none of the 82 cases, there had been exceptional mitigating circumstances which actually led to the reduction of the sanction. Not a single one. And of course, I'm kicking in an open door, but in none of the 82 cases, anything was mentioned about effecting cultural change or to encourage the next generation. And I can assure you, it would be great if that were possible in cases against athletes. We have had cases where an athlete got a 4-year sanction, and that was detrimental to the public support of what we are doing. The general public usually can't really understand the seriousness of that kind of consequences, and it would be great to affect cultural change and encourage the next generation by having this room to leniency if athletes are involved. But it is not there. So I come to my second conclusion. The possibility to consider proportionality is introduced in this award for code signatories, but it is absent in cases where athletes are concerned. Although it may be very wise to consider this kind of stuff if it is about an athlete, it just is not possible. And the main problem, of course, is it is unclear why this difference is there between cases against athletes and cases against a dope code signatory. Thank you for your attention.
Thank you, Herman. And now we turn to Michelle.
Thank you, and thank you for inviting me to speak about the athlete's rights in this particular case, which I think we all agree is a most significant case when it comes to considering really the trust that athletes will have in the world anti-doping system going forward. Because there is no doubt that I think athletes have been left at the door when it comes to understanding how they may have been drawn into this system, or they may have understood what in actual fact may have been going on in Russia at that time. So on the one hand, there may very well be athletes who were part and parcel of the system and very cognizant of their involvement in a system of cheating, which they should clearly have been warned was totally against that which they were obliged to follow. However, there is the possibility that some athletes were not fully aware of some of the circumstances, and that element of doubt is something that I think the CAS panel has tried to balance very much in its consideration. The Athletes' Rights Act refers to athletes having the right that any anti-doping organisation that has jurisdiction over them will be accountable for its actions or omissions through the applicable compliance systems. And an athlete shall have the ability to report any compliance issue they believe exists. Now, if an athlete at that time knew that something was non-compliant, they had that opportunity. And in many professional sports, we see obligations to report elements that are against the rules, such as we see with match fixing. But some of that does depend on whether a system does exist, and obviously the cultural change that Herman has indicated. What we are faced with in this CAS decision is a very interesting conundrum. When athletes join the world of sport, and they join through their national federation by a membership arrangement, which perhaps if they are above the age of a minor, they fully sign to, or if they are a minor or protected person, as we now know them within the 2021 code, perhaps their parents signed on their behalf. They were contracting to an arrangement that, quite honestly, I don't think the code, the compliance standard, foresaw that athletes themselves may not actually be fully aware of circumstances or able to control that which went on in a laboratory miles away from them. And certainly when you look at the need for proportionality, the need for a consideration of the fairness of process, how can an athlete impact somebody's tampering with data that may or may not have been theirs in such circumstances? So I think what we've done, unfortunately, is left athletes way back in this situation, so that when we actually do enter that contractual arrangement with an athlete where they are consenting to abide by the code, that there may need to be, as there would be with all of us, when Microsoft or whoever changes the conditions of and the terms of our contract, that they are notified and they can agree to it. That certainly we need to be doing better for our athletes in terms of their understanding, or we remove them from responsibility for those obligations. And that, I think, has been a conundrum for the CAS panel in understanding how athletes have to be held accountable and responsible for something which they cannot potentially influence. Now, I think that in some respects, the CAS panel has come to a compromise in terms of the way that athletes may continue to compete unless they have been directly involved, and left it with some international federations to still continue their direct action and sanctioning of athletes and athlete support personnel, as obviously World Athletics has been able to follow through with. But there will be other international federations who are going to be very, very poorly placed to be able to follow through in a situation where they can give justice to the athletes. And this is all in an environment where we are very, very concerned that a system that has been in place for 20 years has still managed to let down athletes and at the same time allow other athletes through to profit by their doping. So I'll pause there because I think it's important to get other views on the panel.
Michel, Herman, can I ask you to mute yourself and as well to remove the PowerPoint? Thank you. And now I will give the floor to Jean-Luc Chaplet.
Well, thank you very much. Thank you for inviting me also to this panel. I'm not a lawyer and I have not read the award, which is more than 100 pages, so I will not comment on this, or I will maybe say a few words, but I'm not into the details. I will look at this award from the outside, I would say, from the public opinion side, if you want, because in the end, it is not a traditional case of doping that is an athlete against a sport organization or vice versa. It is two organizations among themselves, WADA against RUSADA. And the decision, the award was very much criticized, as we know, by many people. But in fact, I think it is quite balanced. The word compromised was used by Michel. Maybe this is true, but it is a compromise because, as you know, both parties did not want to appeal the award, meaning that they were maybe not fully satisfied, or even some of them criticized the award very strongly. But in the end, they decided not to appeal this award. And of course, they said, this WADA said, that it is because the Swiss Federal Tribunal rules allow appeals only for procedural matters. It's not totally true. It is true also that you can appeal because of public order matters. But in the end, both parties accepted the award. So in a way, the case is settled, don't you think? We discuss a lot about it, but in the end, the case is settled. And of course, CAS is criticized, but should we criticize CAS? Because if you look at the other tribunals, like state tribunals, in general, they don't accept the request from prosecutors. They actually reduce the request. They lower the consequences that are requested by the prosecutors. And this is what the CAS panel has done in a way. It is not 100% reduced, of course, it's halfway through, I would say. And this is why I would use the word compromise, and I would not use the word leniency. I'm sorry, Herman, but I find CAS was not lenient, it was realistic. And I tried to close this case once and for all. I don't know if it will be the case because, of course, there might be other things, but the two parties, WADA and RUSADA, decided not to appeal. So that will not, this case itself, I think we can say is settled. And if you think of it, in terms of sanctions or consequences, if you want, Russia has been sanctioned and will be sanctioned in Paris 2024, in Tokyo 2020, it was sanctioned in Pyeongchang 2018, and it was somehow sanctioned a little bit, very little, in Rio 2016. So, okay, the WADA compliance committee asked for more, but the CAS panel didn't agree. And I would say this is a good compromise. I like the word you used. I wasn't going to use it, but I wouldn't say leniency. But this is open, of course, for discussion. One of the consequences, but maybe we will leave it for later, is certainly the Rodchenkov case, which that is the Rodchenkov Act, sorry, which has been passed now and is a US law now and might have much stronger consequences than this award that we are talking about. Thank you for your attention. I'm sorry, I don't have PowerPoint, so but I think we can open the discussion now because we have really two points, I think, two slides on this discussion.
So I forgot to mention it in the beginning, and that's on me, but you are invited to submit questions through the chat. So we will select the questions from the chat and pose them to our speakers. So Helen Lenski, also Professor Emeritus, I think, from University of Toronto, has a question, or rather a quote in the chat, and would like our speakers to comment. In 2019, WADA President Craig Reedy said that keeping Russia non-compliant forever would not protect athletes or promote clean sport, and that support RUSADA was a more logical, sensible, and legal route. Do you have any comments? So maybe let's start with you, Herman. Do you have any comments on that?
Yes, and I think Craig Reedy was completely right there, but that is not what this award is about. This is formally an award against RUSADA. But as was already mentioned, basically it's an award against Russia. And RUSADA has been functioning all the time during its non-compliance as a national anti-doping organization, and it should continue to do so, because no athlete or anyone else is supposed to be happy if you don't have a functioning anti-doping organization in Russia. So RUSADA should function and should have all the support that we can give to RUSADA, even if they are declared non-compliant, although that has, of course, a number of consequences. But I think that's another question than what you do with Russian sport and Russian government. Thank you.
Jean-Loup Chaplet, do you have any comments, or Michel?
Clearly, this idea of not keeping Russia out of the Olympics was behind all these decisions, and this award in particular. Yeah, the Olympics are a worldwide event, and we would like to have all countries represented in this event. If not, maybe the Olympics are not what they should be. And I agree with Greg Reedy, we cannot keep Russia forever out of the Olympics. The WADA, the compliance committee proposed to keep Russia out for 4 years. That is until 2028 or maybe later, I'm not sure exactly, I can't remember. But they decided to keep it out until 2024.
What I would like to add is that the WADA system is built on, as Herman says, a functioning national anti-doping organization. And we have evidence that in many countries, that is a known route, a reliable route to get the trust of athletes in their own country for one sort of basis, as it were, in order that they can enter international competition. But I think we have to be aware that the converse of that is that what this points to is an actual breakdown of the WADA system of having separation of laboratory and national anti-doping organization in a way that has allowed them to completely compromise, there's a new look at it, compromise the system. And if the system cannot be allowed to be corrupted, then what I would have liked to have seen arise from the CAS decision is a fresh look at whether enough is being done or the system is robust enough to protect athletes' rights. And I still think that's a discussion that has not yet happened, and that CAS has, probably because it's such a big decision as well, focused on that which was really before it, where we still have not addressed that which McLaren and Schmidt raised in their reports, which is how the system itself is possibly not fit for purpose when it can be compromised and corrupted from within.
May I add something to that? Herman here again. Connecting this to with what Jean-Loup already said, I understand, of course, the reasoning behind what to do with Russian sport connected to world sport. But that is not, and that is the problem here, a legal decision. That is a governance issue, or even a political issue. And the IOC is a governing body, and probably also a very political body, and they should take that kind of stuff into consideration. But this meeting is about a CAS award, and CAS is a legal institution which takes legal action and makes legal decisions. And within that legal framework, it is, I think, not possible and even very dangerous to start taking things about government or politics into consideration. Thank you.
Yeah. If I may say something, I think this is the issue which is behind all this case. It is a fact that in many countries, national anti-doping organizations are not independent from the state, like national Olympic committees, actually. This is because simply the financing of these national anti-doping organizations is coming from the government. Even in the US, my American friends don't like when I say it, but 70% of USADA finance comes from the federal government, which is really unusual in the United States. And so how can this organization pretend to be totally independent from the government? And this is the way the global sports system is organized: national anti-doping organization, regional anti-doping organization, national Olympic committees. In many countries, maybe not in the Netherlands. There are a few countries probably where they are more independent than in other places. But in Switzerland, for example, in my own country, the budget comes 3/4 or 2/3 from the government, federal government, and 1/3 from the Swiss Olympic Association, that is the NOC of Switzerland. So this is really the issue which is at the basis of this whole thing, I think.
I can see there are comments around the fairness of the sanction, in the comments in particular Nadej, who says that it seems unfair that a player gets a 4-year sanction and doping system 2 years only. How can we be sure that it will not happen again? Well, I guess we cannot be sure. But I wanted in this respect, I wanted to add something that I think we did not mention so far with respect to proportionality. That one of the first thoughts of the panel about the 2-year versus 4 years was that it has never been WADA's intent to include more than one winter and one summer edition of the Olympic Games each, if I'm not mistaken. I did not review the award right now for that. But that's another interesting parallel to make, I think, Herman, with individual doping sanctions, because as far as I'm aware, but maybe there has been new case law, but CAS panels have always refused to look at the calendar of the athlete and look at as to how the timing of the sanction, given the competition calendar, was actually affecting them. So to provide for a form of equality of sacrifice among athletes. And I think that the CAS panel has never done that for athletes. So it's interesting that they seem to have thought of this consideration with respect of the Olympic Games that RUSADA would miss. So I don't know whether someone wants to comment on that or add something.
Well, I agree completely. This is a big difference and an important difference between the approach towards a code signatory and towards an athlete. We all know that that kind of considerations about what are the consequences on the calendar and the participation in sport events has been part of many decisions of sports federations themselves. And still it happens that you really take into consideration whether 8 months or 6 months or whatever will mean that that person can or cannot participate in a certain event. But CAS always, as you say, refuse to do so, and I think rightly so. So this is a new element as well, and it is not explicitly said in those many words, of course, in the award, but we can all see that that has been part of the considerations of the panel. Thank you.
One of the points I'd like to come to is the comment about how can we guarantee this won't happen again? And I think actually we cannot give that guarantee, and that's what points to whether this should be instructive about the future arrangements that anti-doping does need to consider, that the move towards the operational independence of the various stages and organizations within anti-doping, it's almost impossible to create absolute independence, because people come from somewhere and funding has to come from somewhere. And we have a UNESCO convention that talks about governments being able to fund, and part of compliance is governments funding. So you naturally bring in a responsibility, and there will be very few governments around the world that will be willing to give money without some form of accountability. The question, of course, is about that accountability, but that's the same as we're expecting of the athlete, because we want the athlete to be a part of our sports system, and we want them to be accountable for competing doping free. But at the same time, we must support them with the right kind of support mechanisms to enable that to happen. And the problem, I think, for anti-doping is it goes so far and not far enough. And that in itself means we're trying to create perfection when we have to base our the system in reality. Money comes from somewhere and the athletes come from somewhere, and if we want sport to continue at a national level, or we go back to the Olympic Games being just those who happen to be on holiday in that country at any one time, and there are Olympic athletes. So that's really what we have to see. What do we really want as the future of sport?
Jean-Loup, what do you think? Is it inevitable that if you have financing, and we all understand that financing has to come from somewhere, is there a way to improve independence in spite of dependence on financing?
Of course, and it is. I fully agree with what you said. It is impossible to be totally independent. Even universities are not totally independent. They receive their funding from the state in general, from the canton in Switzerland and so on. So, but it is possible to be better independent than others, or it's a question of degree of independence. And some countries are certainly better than others in terms of independence. And unfortunately, the RUSADA is not, in my opinion, independent enough from the Russian state, and this is really the problem at the bottom of it, at the bottom of this issue. It's the independence of one national anti-doping agency. Actually, this is, I think, why ITA was created also, so that the tests themselves could be more independent from a country. And from sport also, because there you have the same issue of independence from sport, sport.
But maybe I would like to add to that, because there is also a mythical here attachment to independence, in the sense that even a purely independent RUSADA that wants to do its job, if the Russian government, with its resources, decides that the Russian athletes that have a chance to participate in the Olympics are going to be trained in a certain way and have access to doping material, I'm sorry, but RUSADA will just not enter the closed zones, military zones, and that's it. So I don't think here there is the real core question, I think, that we are facing also is in terms of deterrence. How do you deter a state to engage in the type of systematic doping that has been uncovered in the Russian context? And how do you deter without also causing too many, let's say, collateral damages? And here there is a question of the innocent Russian athletes. Many of them have probably been forced to enter that system if they wanted to participate in their sports at a certain level. And here I think there is really a room for criticism with this judgment, and there is always room for criticism, I think, in any type of judgment from any court, to say that the CAS, well, I think there was room to be more lenient with the athletes, but to still preserve a certain amount of deterrence with regard to Russia. And what I felt, at least in terms of the sanctions or consequences that I thought could have been maintained much stronger, are more related to the visibility of Russia during those international competitions, rather than necessarily the access of athletes. So, and maybe this is connecting to Michel's presentation. I was wondering whether indeed, and coming back to the question about the really heavy sanctions that athletes face. I mean, this 4-year ban is really career destructive. And the relatively lenient sanctions that were imposed on Russia, whether there is a way, and this is for the future, because the ISCCS is a moving document, and WADA could review it and ensure that other sanctions be clearly made part of it. What type of sanctions could we imagine that would affect countries without affecting too much potentially innocent athletes? And that's a question that I would like to direct to Michel.
Thank you, Antoine. It's interesting to see, I think, this already being put into action by WADA through their letter of 21st of January, when they tried to encourage the Secretary Generals of the international federations to identify the Russian officials sitting on boards and committees, and also the athletes potentially entering future world championships between that date, January, and December 2022. So I do think that what we are seeing is a move towards a more intelligent approach to where our risks could be. Are they with certain influencers in committees? Are they with the athletes? But at the same time, I'm also slightly concerned that there is quite an emphasis on this only being something that ever happens in one country. And I think most athletes would say, actually, we think there are far more countries who have this kind of involvement. And it reminds me that when we sat in Lausanne in 1999, we were talking then about exactly the problem of state involvement in doping, and the problem of East Germany, potentially the problem of China, maybe other countries. And that in itself is what led to what we have presently, this balance of sport and government to try to hold each other accountable. And perhaps what we're failing to do is actually listen again to that voice of the athlete that spoke up from the back of the room that said, we don't trust either of you. You really do have to sort this out between yourselves and hold each other accountable. And perhaps that is where we are slightly missing the opportunity for keeping that accountability going on either side, and the athletes holding both to account.
Well, if I may add something, indeed, I think we all have to fear that Russia is not the only country which can do something like that and actually is doing something like that. I think it's realistic to think that this is not a unique case. And when you look at the way this case surfaced, it was indeed a German journalist, and he got behind it, and he got it into the open, and then the ball started rolling. So the system fails in terms of really this kind of systematic state-sponsored and state-led kind of corruption. I don't think the system is fit for it. The system that is there, what we are talking about right now, the international standard for code compliance and the consequences as they have been decided on by CAS, are for that exact reason as serious as they are. Because the system that we do have even failed to put the most serious consequences possible onto the country. So this is a dead end. And I see that one of the questions by Michael asked is the CAS system trustworthy? Well, my opinion would be, generally speaking, when athletes and other persons are involved, the system works, although I think there's a lot of improvement possible. But when it comes to this kind of really, let's say, big interests in terms of the sport as such, the sport structure and international political sides that come with it, no, the CAS system cannot do what it is supposed to do. There should be an alternative. I don't know what the alternative should be, but CAS certainly cannot do it. I think we all agreed, and Jean was very clear about that a number of things which are not legal were taken into consideration. And CAS, of course, is much too close to the IOC. The president of CAS, or of the governing body, is the vice president of the IOC. So as long as you keep the system as it is right now, it's even less possible to make any progress, I'm afraid. Thank you.
Yeah, I agree with what you just said. The reason for all this, CAS is not fit for resolving issues between states. And the only way to settle things between states are treaties. And both sides have to agree, or several sides have to agree to a treaty. You cannot make a state compliant unless you go to war eventually, or very extreme means. But if the Russian state or any other state doesn't want to do something, it will not do it, simply because this is the way the world is organized. And there are state parties in international treaties, and they might agree on something, and they have agreed on something in the UNESCO Convention. But there are no sanctions for states in the UNESCO conventions. That's the basic.
Exactly, but I think that if you want to look for a solution, you should look in that direction. There are even two international conventions, as you know, the Council of Europe and UNESCO, which could be very relevant, basically, if there are consequences to non-compliance of countries, of those states that adhere to that specific convention. That should be a more suitable tool to reach what we are looking for. But at the same time, we do know that we don't get very far there. There has been a discussion about consequences, excuse me, concerning these conventions. And the discussion ended where basically a few countries wanted it to end. And the consequences are, well, basically almost non-existent or symbolical or whatever you like to say it, but nothing serious comes from very serious ways of not doing what you're supposed to do. Thank you.
But I would like to add on this point, it's really an interesting one. how much should we turn to international law? I think one thing that is also important to note is that even when international law or European law comes with consequences, let's think of the European Convention for Human Rights. Russia is a signatory. Russia can be brought before the European Court of Human Rights. I don't think many human rights lawyers would say that right now this has been in any way a mechanism that has had a lot of influence on a variety of practices that are deemed human rights non-compliant in Russia. So I think it's important also to be maybe also a bit pessimistic about international law treaties providing a solution here. But I think the problem is clear, is that we have a global system, but we have a lot of local actors that have a lot of power in how the system works and that can play that system really well. And we have entered a new phase with the WADA compliance standards, in which WADA is trying to police really those local actors. But it's still relatively weak. It has very few people. However, it can be helped as well by external actors like journalists. The question that this case is posed is, what are the consequences and how do we deter states that in the end have an interest in getting their athletes at the top of the podium on the Olympics? If Russia does that, it's because they want to see their athletes at the top of the podium. So there is some leverage, I would say, on the side of the Olympic movement. The question is how to exercise it, and through what type of consequences or sanctions can this leverage be exercised to lead to some type of behavioral change on the side of the state, not necessarily on the side of RUSADA, which seems to be a very weak actor. Do we have any other questions? We had, I think, one more question from earlier, no? About the politics of CAS. Well, it's connected as well to the discussion we just had on CAS.
Yeah, I just wanted to maybe to come back to this, the question by Michael asked, the second part, is arbitration the right way to solve anti-doping cases at all? Well, without going maybe into the broader question about whether CAS should be dealing with anti-doping cases, I think what was clear in this case is when you have these special circumstances where you have WADA trying to impose basic consequences on the whole world, the CAS is struggling procedurally with sort of trying to bricoler solutions to decide on who is going to be a third party with what rights. There was a dispute as to what aspects of the case intervening parties that had been admitted to the proceedings were allowed to reply. So, for example, the intervening parties were only replying on the consequences and did not have access, according to the CAS award, at least did not have access to the forensic data. So they could not, the panel did not authorize them to make submissions on compliance or non-compliance of Russia and have access to that data. So even in terms of proceedings, if you have those cases in which you don't have a simple case with an individual and a federation, it can be a big procedural mess to know how to hear all those individuals and those entities and try to make a decision that will then have effects even on parties that have not intervened in the proceedings.
I don't see any other question. Are there maybe a last round for our speakers? Would you like to do some maybe closing remarks to share final views on this award and maybe on, let's say, the future of the anti-doping system looking forward? What maybe would you change, or can it be saved in a way?
Well, that last question, I certainly am not going to make any closing remarks on, but still, it's in my mind the short discussion we had about independence of anti-doping organization, and that goes on two levels. And one level is the formal level. How put you in a legal framework which, at the very least, on paper makes an anti-doping organization independent. In the Dutch legislation, it specifically is said that the minister cannot mess with my decisions. And if he does, I could go to the press or parliament and he would have problems. So that's fine. Still, if he was my neighbor and a good friend, we still could do a lot together to make the world as we would like to have it. He's not, by the way, not my neighbor, not my friend. But the problem is that this first stage, making sure that there is a legal framework, is not even there in many countries. So the first step should really be that you, at the very least, you make sure that there is a framework which stresses the independence of anti-doping organizations. The second level, the cultural, political, historical level within a country, is even much more difficult to approach. But at the very least, we should take care of that first level. Thank you.
Maybe Jean-Loup, would you like to add something? Michel?
I think Jean-Luc may not have unmuted himself. So if I could just offer some thoughts, because the one thing I think we've got to bear in mind is that if we don't remember the past, we are definitely, likely to repeat this time and again. And I ask the question whether it's possible to impose fairness through WADA code standards, whether actually we need to have a simpler thought about what fairness really means when it comes to independence of operation. And I think that's a conversation that the anti-doping movement and the athletes should be having this year about operational independence, what it truly means, because you have to balance accountability for the finance against obviously the decisions that can be made. But if we're thinking about independence, would we consider that the Olympic movement has an independent approach in the way that it operates? It claims obviously that government shouldn't intervene with the national Olympic committees, and then of course we have to look at whether or not that it goes beyond the meaning of the true meaning of independence. So I think from an athlete perspective, you've got to ask yourself whether or not this is still about fairness, and a new approach to operational independence is definitely needed.
And Jean-Loup, this time, if you
I will not talk about independence. I think I've talked already a lot about it. I will say a few things about the future of anti-doping system. Clearly, there is a new trend which we will have to take into consideration. It's the eruption, I would say, or disruption from criminal law into the system. We've had a few cases recently. You followed it probably. Anderlas affair in Germany and Austria, I think. Also the Schwarzer case in Italy. I mean, these decisions are involving anti-doping or doping into criminal law. And this is, of course, rather new, because the World Anti-Doping Code and arbitration has tried to insulate it from law, from domestic laws and so on, by making it a separate system, if you want, only for athletes, not for states actually. But this is why now we have to look at this new trend of more and more cases being discussed, also not only at CAS or in WADA, or in sports organizations, but also in tribunals, in courts, in state courts. That's really a new trend, and I don't know what will come out of it. But we might very well have contradictory decisions between state courts and the CAS itself, or the WADA system, if you want. And that might create issues in the public opinion and with athletes, because most athletes are absolutely not aware of this, and they will not understand why decisions are on one side white and on the other side black. Thank you for your attention.
May I try to, sorry, Marjolaine. I see that there's a question from Antonio, our Portuguese colleague, and I think maybe also to end on a more positive scale, I would like to try and answer the last question. If something like the Russian thing happened again, are we now better equipped to help support and protect the whistleblowers in a case like that? And thank God, on that case, I'm quite positive and optimistic compared to all the other issues, because I do think that now WADA is in a much better situation to help out, to make sure that whistleblowers are protected, and that measures are taken necessary to help them to do the job they want to do in a safe way. So whatever has gone wrong, and many things went wrong at the time, that has been a lesson learned, I think, by WADA, and I think it's on a much better level now. Thank you.
Yes, I was going to use this same comment actually of to react to this comment by Antonio Nunes to conclude, and then I will let Antoine to close. With respect to protecting clean athletes from Russia while sanctioning Russia as such, in the end, to me at least, the CAS award does strike a relatively good compromise in this respect, because it imposes no collective punishment on Russian athletes for being part of this country, and it does not impose any burden of proof on them to show that they were not implicated. So in the end, if you want to be able to have a pressure on countries while not punishing individual athletes, this solution of competition as neutral individuals, well, then you have to discuss the modalities that the CAS panels imposed that were not necessarily the modalities that WADA wanted. But this seems to be, in the end, the only solution when cases arise to try to have the better of both worlds in a way. And on these words, I will leave it to Antoine to close. But thank you to all to the audience first, and of course to our three guests. And we'll be back next month, hopefully.
Yes, thank you to you three for your thoughts. I think it was a rich discussion, a lively one. I hope the participants share my view. We will share the video of the discussion on our YouTube channel, the YouTube channel of the ASA Institute. So if you want to rewatch it or to go back to certain aspects, you will be able to do it in the coming days. I want to thank you all for participating, and indeed, we will be back in approximately 1 month for a new Zoom in on a different sports law case. Until then, I wish you all a good evening if you are based in Europe, and a good day if you're based somewhere else. And see you soon, hopefully.